Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, here we go. Another episode of Military Justice Today. We're back in the studio. I'm Matt Starosiak. Sitting across the podcast table from me is none other than Robert Capovilla. Hello, Robert.
Hey, Matt. How you doing?
I'm doing great. We're in the podcast studio a lot these days, aren't we?
Yeah, it's great. We love it here. They do a phenomenal job for us here.
How fun are the podcast episodes on a 1 to 10?
They're easily one of my most favorite things to do in the line of work that I do. I always look forward to being in here. So if sitting down on Saturday afternoons during the fall and watching a Buckeye game is a 10, I would put the podcast at a 9.
How often do you loop the Buckeyes into the podcast?
A lot. Well, our listeners know that you're a Michigan man and I'm an Ohio man, and one of us is known for cheating and sign stealing, and one of us is known for Ulysses S. Grant.
Hey,
so
fair enough. Although I'm a Michigan State guy, I think most of our listeners know that by now.
That's true
as well.
too. That's true too.
Well, it's great to be with you today. We've got a great episode on tap here. We did one recently with a father of somebody who you represented in a general court-martial, and today we actually are privileged and honored to have one of your former clients. And we'll call him John for this episode. John, are you with us?
Yes, sir.
How you doing today?
I'm well. Thanks for asking.
Well, thanks again for being on the show. I'm going to talk just briefly about your background, and then we'll throw a pre-show question at you, one of our kind of standard ones, or maybe let you choose. But we really do appreciate you being on the show. Rob and I have been talking about this for a while, and we're certainly looking forward to it. So you are an Army veteran and officer. You served 10 years. You're a graduate of the U.S. Military Academy at West Point. And I believe you were represented by Rob about a year ago, maybe a year and a half ago?
Yeah, the representation ended about 7 months ago.
Okay, great. And the result in that was favorable, and you're going to talk today about kind of your experience going through the process, and obviously your experience with, I shouldn't just say Rob, it's really the Capovilla and Williams team, but I know Rob was lead counsel on it. So we'll get started in a minute into the nitty-gritty, but as you know, we always start the show with kind of a pre-show question, some meaningless chatter between us, and I guess I'll give you the choice of what you'd like to talk about. And how about maybe your favorite military movie or movies? That would be option 1. Option 2 would be the most famous person you've ever met and where that took place. Or one of the things that we've been debating here during the shows and also during the breaks is if this Mike Tyson and Jake Paul fight actually happens, who's going to win? So you're our guest of honor, and so we'll let you choose which question to answer, and we'll talk about it a little bit.
Sure thing. I'm going to not shake it up. I'm going to go with favorite military movie. But I am going to give I haven't heard this answer much on the podcast. Generation Kill, the miniseries that was on HBO. It's about the invasion of Iraq with the Marine Corps Force Recon. There was a Rolling Stone article about it. And the reason I think that that's my favorite piece of military media is I think that captures just in essence the culture of what it's like being, for lack of a better word, a global war on terror veteran. You know, everything from the way people carry themselves to the language to, kind of dealing with an ambiguous foe. It resonated with me both as a young man wanting to join the military, and once I actually went out, I did the job, honoring. It made a lot more sense to me. So.
Well, that is one thing about your background that we didn't mention that we probably should have, is you are a combat veteran. You served in combat in Afghanistan, and we thank you for your service. And I know, having worked with you for such a long time through a very difficult process, that your deployment there was something that left a lasting impact on you. So thank you for your service, and I understand why you picked that particular show. It's one of my favorites too, and I think it's been lauded across the country as one of the most accurate, displays or portrayals of what the war on terror really was like. But we could probably go on all day about that. I want to shift our gears now and talk a little bit about your case and about your situation. And I just want our listeners to understand what motivated me to invite. Right now, it doesn't take a very long time, or it's not hard to find on the internet, on social media, that the U.S. military justice system is under attack for how it treats alleged victims, for the rights allegedly available or not available to these victims. There's hearing in Congress about more victim rights. There's hearings in Congress about how to protect victims more, and all of that is an admirable cause. The reason I wanted to bring John on the call on today's episode was to show the other side of the story, that with all of the pressure being placed on the United States military right now, in particular by the Biden administration, to be as aggressive as it possibly can be in sexual assault cases, that there are men and women in uniform who are 100% being falsely accused of crimes they did not commit, and they're being taken to trial on cases that the state and federal governments, our counterparts, would quite literally laugh at. And that's why I wanted to have John on the show, because I wanted to educate our listeners on what's really happening to our service members behind the scenes. So, John, with your permission, I'll go ahead and share a little bit of just the basic facts of your case. I know this isn't going to cover everything by any stretch of the imagination, but I do want to at least share the basic facts, and then I want you to kind of talk us through the different steps of this process and what it was like to be the man who was falsely accused. So that all being said, as I've already stated, John was accused of sexual assault by a woman that he had a relationship with. And what I can tell you, in that all the years that I have been working court-martials and all the years that I spent as a prosecutor and a defense attorney, this was the case, or one of the cases, that confounded me the most, because we had hundreds of pages of evidence and text messages and communications that left absolutely, positively no doubt whatsoever that John was not guilty of sexual assault. We literally had text messages where the accuser was talking about how much fun she had with John during the exact same time frame of the allegations. We literally had photos that she was sending him during the exact same time of the time frame. We literally had, on the day this stuff allegedly happened, text messages where she was thanking him and telling him how much she enjoyed being with him and how she couldn't wait to see him again and how in love with him she is. Then they break up. They decide to part ways. And several months after that happened, John finds out that he's under investigation. And I can tell you that when I first got this case file, Matt, I read through it and I said, okay, this is going to be one phone call to the military prosecutor, one phone call to somebody with some common sense, and we're going to get a victory for this guy. These allegations are going to get dropped.
You'd think that you'd know better at this point, that wasn't happening, but that just tells you how bad, this was,
right,
and miscarriage this was.
And not only did the prosecutors ever refuse to admit they got it wrong, they prosecuted this case with a vengeance. And it turned into a heavy litigated case. It turned into a case where we had to fight tooth and nail just to get the evidence to show that John was 100% not guilty of the crime. And it's a case that sticks with me. So with that being said, John, I don't want to get into the nitty-gritty of the details, but I do kind of want to turn it over to you at this point to tell us a little bit about your story. And I want to start with, what was that moment like when you found out for the first time that you were under investigation?
That was, barring some stuff that happened downrange, that was probably the worst moment of my life. I remember I was in a school at the time, and my instructor, who I'm friends with to this day, he walked up to me and told me, "Hey, John, I have to escort you to CID." And it was just an attack on your identity. And from that point on, it really became a them versus me experience, and quite literally every sense of the word. I remember I went into CID. They sat me down. The rigmarole of, hey, like you're not being accused, you're a suspect. And, suspect just means that we're trying to get the facts, which, of course, they're lying. That, for the listeners, if they're calling you in, they already think you did it. So approach it always, just invoke your right to silence and get a lawyer. I told them I didn't want to talk to them without a lawyer present. They let me sue for like another 20 minutes, and then they went and did the titling process. And that's really, I know for your listeners, that's where it'll show up on background checks that I was arrested for these things. I think the cognitive dissonance was when the guy who booked me, he was taking my fingerprints, and as we were cleaning the ink off them, he's like, fun fact, these smell like tangerine. And it really just kind of showed me like this was business as usual for CID. Like, this is the worst day of your life, but no one really sees it as that except you. And I can obviously go on, but short answer is that worst day of my life.
Yeah, and Rob, I think that's a common theme, right? I guess a couple things. One, these accusations tend to come at a complete surprise for a lot of your clients, right? So some might know that something's brewing or something may happen, but for many of these folks, I know from having spoken with you, it's a complete surprise, and it's an all of a sudden thing where they're being pulled out of their job or their duty and being dragged in and interrogated. Is that right?
Yeah, that's common. Most of our clients are have no idea why they're being taken into CID, and they're not told. They will be told what the general allegation is before they're asked to give a statement, but they're not told about the facts. And typically speaking, Matt, by that point in time, CID has already interviewed numerous people and they've conducted a full-scale investigation. So they know what they perceive the facts to be.
And do you think made up their minds at that point in many cases?
Well, I don't even think it's my opinion. We know they made up their mind because they titled him. They're only supposed to do that if they have probable cause to believe a crime was committed. And the important thing to remember that I hope every listener who hears this is afraid is that they read or they titled John before he even got his side of the story out there. The second he said, right now, I want a lawyer, they said, you know what? We're titling you. And CID, from my perspective, they've gotten better as the years have gone on, but they conduct very biased, one-sided investigations. So none of this surprises me. This is normal. And, you know, it's not shocking. This is how they conduct business.
I think I'm certain most of the folks on who listen to our podcast will know what the word titling means and know exactly, but some might not. If we have a parent listening or somebody else, can you just say briefly what that titling? You said it goes on a permanent record type of thing, but can you kind of define that without us getting too far off track?
So this is not as easy of an answer as you might think, because what CID's definition of titling is different than how I've perceived it over the years. What I tell people is it's how they arrest you in the military. They take your photograph, they take your fingerprints, they take DNA out of your mouth, they tell you it's for administrative purposes only, and then that is uploaded into a database, a federal database. So any background check that you ever have moving forward, that's going to come up that you were arrested for sexual assault, abuse, sexual contact, whatever.
Regardless of the final disposition.
Regardless of the final disposition. The case could be dropped 2 weeks later, and that's going to be on your background for the rest of your life. And a lot of times, CID does not do a very good job updating that disposition. They will not say charges dropped, cases dropped. They'll leave it open-ended. And we have clients that call us from years ago that say, hey, I went to go buy a gun and I can't buy a gun because they said I'm under investigation for sex assault. And then the process is what going through now, working with Josh Conklin from our office, and in part is to try to get that removed. And that's a very difficult thing to do. But I don't want to get off on a tangent with that. John, one of the things that makes you unique is you ended up deciding to eventually give your statement to law enforcement. And you gave one of the most complete, one of the most accurate, and one of the most detailed statements that I'd ever seen somebody accused of a serious crime give. Talk to our listeners a little bit, John, about what was that process like being interrogated, you know, and why was it important for you to get your voice out there early?
Okay. Well, first and foremost, I want to make clear that I did that against the advice of my original counsel. I retained counsel and their advice, as in every case, if you're facing these charges. just wait, be quiet. I know it's hard. We'll talk more about that later. But I ended up kind of firing that original counsel because I had seen a warrant basically for communication between myself and the woman who was accusing me. And I noticed that it was, for lack of a better word, not going to return any evidence because there was critical information withheld regarding certain usernames from my accuser. Essentially, they were only looking for communications between a Smurf account of hers and my actual account. So I noticed that, and I wanted to give a statement. At that same time, I'd also been informed that the government pulled the entirety of my medical history because I told my chain of command I was experiencing heart palpitations because of the stress of the investigation. And they were trying to charge me with malingering. So my original counsel had told me, 1, there's then preferred charges against you. 2, they're trying to charge you with malingering. And 3, here's this warrant. So I hired another firm, and they were like, yeah, you very clearly didn't do this. If you want, we'll go with you. And I gave a statement. And the statement was like 3.5 hours long. I walked through everything to my recollection of my relationship with this person. I wasn't asked any questions by CID during this time. They kind of just let me run my mouth, which I was perfectly fine with. And after I'd given this statement, I also elected to take a polygraph examination, which of course isn't admissible in court, but I was doing everything I could to be able to look. At the very least, you should look into my side because I told them where to find exculpatory evidence. I told them I knew that this exculpatory evidence existed. And more importantly, I kind of highlighted that, like, just by virtue of your warrant, you're not getting the full story. I went to extreme depth to spell out what accounts they should be looking at, what online evidence they should pursue. And much to my chagrin, I later found out that, 1, they didn't look up anything I asked them to. In fact, they then took my statement and basically gave it to my accuser to basically plug holes in her story. The whole decision making was behind that was because I truly believe, and I still believe, that like the things I fought for and the things I've seen people fight for cannot be taken away just by virtue of the fact that you're accused. And Rob has talked about this pretty in depth as well. And I believe that they were going to give me a fair and impartial investigation. Obviously, they did not. But yeah, that's the long and short of that decision.
And just to kind of put this in perspective for our listeners here, so that they can understand what happened and what we were dealing with. When I got when Capovilla and Williams was hired and I decided to serve as lead counsel in this case, and I finally got the discovery, I had a transcription of John's statement, and it was long. It was over 120 pages, I believe. I read every word, and there was nothing but common sense explanations and outright denials of all wrongdoing. And then in the CID report itself, Matt, the report of investigation, there was a paragraph in there that went to John's command that said, literally, John corroborates victim's story of sexual assault by admitting intercourse occurred. So these two people were in a relationship. That was never in dispute. John denies everything and passionately denies it, and then literally tells them, here's where you can find the evidence.
That supports what I'm saying.
That supports what I'm saying. And he's literally begging them to go get it. It's in the transcript. Go get it. If you want to know the truth, you'll go get it. And the only thing that CID could write was that John's account corroborated that intercourse happened, which helped support the idea of probable cause. That was the only thing they updated the command on regarding his statement. And so when I saw that, I thought to myself, my goodness, this is getting a bit ridiculous. This is getting a bit crazy. And the sad thing is it wasn't that outside of the line of what I've seen in many of our cases. And the crazy thing about this, and I kind of want to shift now into the motion that we filed to get your accuser's phone. And we'll talk a little bit about what it was like finding Capovilla Williams and all that kind of stuff. But I just want to give the listeners a bit of a heads up. He says that CID was only interested in the alleged victim story. Let me tell you what that means. The discovery in the case contained text messages where the alleged victim herself, and I, you can bleep this out, Matt, I shit you not, this is the truth. The alleged victim herself printed out a copy of her and John's communications, then took a Sharpie and lined through about 35% of it with her hand, gave that deleted copy of evidence to CID, and CID said, "Oh, this is great. Thank you. This is wonderful." The government, the prosecutors, made no attempt to sign a subpoena to get the communications. CID made no attempt to get a warrant to get the full communications.
And probably didn't even ask
I
her,
felt
right?
like
why are these redactions on here?
I felt like I was living in La La Land. And then to make matters worse, when we filed the motion and attached, I literally took these deleted messages and put them in my motion, which by the way was 73 pages long. The government's argument was they provided a statement from the accuser saying, I didn't delete anything. I didn't delete anything.
Yeah,
and then they argued that in court. They argued she didn't delete anything. And we have the document right there that's lined through. And it was like John and I were living in La La Land. But John, before we go on and we talk about motions and litigation and what it's like to be with an attorney in that courtroom, what it's like to battle for your rights, what it's like to battle, in this case, your chain of command, because we filed a massive UCI motion. Talk to us a little bit about that process. You're charged. The state, they don't take in consideration your statement, and you say, okay, now I need to go find trial lawyers to help me. Obviously, you picked Capavilla-Williams, which we appreciate, but just kind of talk about what that process was like for you, because I know a lot of our listeners might be going through that process.
Yeah, so a few things before I get into the process of finding you guys and what happened afterwards. Matt, you asked the question like they probably didn't even ask. They actually did ask in an email because part of the evidence against me was also like handwritten evidence of things that my accuser was saying I said, but didn't have. Keep in mind, she took copious screenshots, didn't have evidence of any of this. They asked her like, "Hey, what did you say back?" Because of course she didn't record anything she said, and all she said was, "I'll think about it and get back to you," and she just never did. That's an email conversation from about a little over a year into the investigation. I spent 14 months on the investigation, so that sucked. But once I found out I was charged, well, first things first, I was on leave, and my chain of command, my commander had called me off of leave, had me report, and was very. I walked into a room, it had legal, I guess brigade legal in there, people I never saw again. My commander, my first sergeant, I reported, and then they just started reading off charges. And one, they were very confrontational. They had told me, "Hey, we have an update on your case. Come on in, we'll talk about it." So they didn't even give me a heads up. But I told my father, I was like, "Hey, Dad, I think it's finally over. Finally get to move on with my life." And my phone rang during it, and they admonished me because my phone had gone off. Notwithstanding, command reached the charges. There's a count of sexual assault, which is, for your listeners, because there's a differentiation I've learned, which alleged that I had a relationship with this woman without her consent. And then there's a charge of rape, which was alleging unlawful force. So they didn't.
So I guess, John, just sorry to interrupt you, but so you're thinking, okay, this is going to be closure. They're bringing me into this meeting, and it's going to be closure for me, and we're going to put this thing, to rest. And it ended up being just the opposite. And it sounds to me like they kind of disguised that meeting as an update when really it was going to be a blind side of all the charges against you. Is that right?
Yeah, that's correct. The command will always claim that they had cleared the building out, like they respected my privacy. I was there. I'll tell you, that didn't happen. They perp-walked me in front of my subordinates. I was a staff primary because that's what you do as an officer when you're flag, unfortunately. And they, everyone, but I remember one of my NCOs, he was like, "Are you good?" And I was like, you have to put on a strong face and be like, "Yeah, man, I'm fine." And I had a kind of a war chest where, like, if in the event that this ever happens, I'm going to bring this to bear. And I asked them if I could just stop by my home, which was at the time on post, to get this. And one, they wouldn't let me until I begged. And at that point, they entered my home because I did it like there's a concern with command that you might hurt yourself. But at no point did I ever even communicate that I was suicidal, despite their claims. They took me to TDS. They had given TDS about 30 minutes notice that they were charging me. So when I got in, I didn't even get to talk to anyone. I talked to the lead TDS counsel, who he informed, like, "Look, I'm not going to be on your case. I'm going to assign it to someone else. But like, this is the process." And you just, it was very hopeless feeling, particularly because he even highlighted, like, "Look, man, I didn't get a lot of time to prepare for this meeting." So I spent 30 minutes with them, and then they took me to a command referred behavioral health appointment. And what that is for your listeners is basically your command is alleging that you are mentally unstable and that for one reason or the other, you either need to be committed or you need to have some serious mental health treatment. So they went into there, and I have my medical records from this, basically alleging that I was keeping secrets, not telling everyone the full story, that I was imminently suicidal, and that, for lack of a better word, I was dangerous. And this commander, after the fact, we'll get into this later, but was in fact very biased in his perspective of me. And then I went into that behavioral health meeting without really discussing my personal conversation. It came out that, hey, I'm not suicidal. I'm just very frustrated with a process that to this point has not been fair to me. And I feel like no one's really caring that, I didn't do this, and now I have to go to a full-on trial by court-martial. But that was the referral side of things. So I get home, obviously devastated. I told the attorney that was representing me, and I wasn't in crisis, but it's a heavy feeling to be looking down the barrel of what's essentially 30 years to life in prison. And I looked up military defense lawyers one more time, as I'd done twice before when I hired the other two guys. And I saw Rob's page, and I don't know really, I've seen it before, and I had actually passed over it because
you didn't like the way he looked.
I don't blame you.
Not at all. It was more just along the lines of, like, I didn't think this was going to turn into what it was. So, I read a lot of Rob's testimonials, and I experienced his diligence as a trial litigator, but I didn't think I was going to be charged. So that was when I decided that I needed someone to really fight. And without sounding too much like a plug for Rob, I hired him, and instantly it was everyone else that I hired up to this point was like, well, we'll wait and see. Rob was the first person to tell me that he was going to help me. Now, he didn't make any guarantees, and I don't think as a lawyer you can ever make a guarantee. It's irresponsible. But it was funny because one of the lines that sold me was Robin told me, he's like, "Look, man, if you hire us, we're going to know Captain Tapavilla's on the case, and they're all going to know what that means." And I was like, sold. Let's move forward. And then, I retained Rob, and we moved forward. Does that answer your question, Rob?
Yeah, that was great. That was great, John, and I appreciate that. And there's a million things that happen between Capavilla Williams being hired and also where we're going to go now, which is the motions hearing. And of course, we've got to give John a little bit of a shout out to my co-counsel too, Matt Jubelt, who is a member of our team who we brought on to help with some of the intensive motions that we knew we had to file in this case, because it became very clear to me early on that there were some real procedural problems that happened in this case. And I was intent on bringing that to bear in court. I was intent on exposing what I felt was injustice happening to my client in court. And to go to John's point about the command referral mental health side of things, When I was brought on, one of the first conversations I had with the prosecutor was, look, this guy is not suicidal. This is ridiculous. Why are we harassing him constantly about his mental health? And the prosecutor literally said to me, well, we think he's got narcissistic personality because he refuses to admit what happened. And so I remember thinking, you're damned if you do and you're damned if you don't. They're literally thinking he has a mental health problem because he's saying, I didn't sexually assault or rape anybody, which, oh, by the way, the evidence strongly supported.
Yeah, there's no win to that response for John. And you know what? Thank God you weren't suicidal, and thank God you made it through this process. But as I sit here listening to the facts and how it played out, it's understandable that you would be suicidal.
Right.
And Rob, I know you deal with that with some of your other clients. I mean, I can't even imagine how I would begin to feel if I had to go through what you just described.
So
briefly.
Go ahead, John. Yeah, no, you're good, John. Go ahead.
So, frankly, Matt, I'm pretty well versed in the red flags with the Army. Obviously there's SARS related things, but there's also suicide, right? The Army takes this stuff very seriously. And it's not that I was not depressed or that I didn't have those thoughts, but there's a distinction between being, having those thoughts and actually having a plan to act on them. And that's gleaned from my several years of counseling that I have pursued in the wake of this. But regardless, one of the conversations I had, and it was one of the most tone-deaf kind of conversations that I understood that my commander had my battalion commander pulled me aside the Christmas after I was charged and had told me, like, hey, John, like, let's be real. Most people would have put a gun in their mouth and called it by now. Not something you want to say. And he was framing it as, hey, you've been very resilient through this. But I was frustrated by the fact that no matter what I did, no matter the fact that I performed, and there are statements that laud my performance even while this was going on, that all anyone thought was like a guy that was, mentally unstable. And, it's funny that these lawyers, just a side note, that the prosecutors plead that, like, oh, we think he has a personality disorder. They literally pulled my entire medical history. Like I said, to try and charge me with malingering. They thought I was lying at the heart palpitations. The fact of the matter is they just never refused, or they never wanted to acknowledge that I was telling the truth, because their whole argument, we'll get into this emotions, was that I was a liar.
Right. So I'm going to talk now about leading up to the motions hearing, which was a remarkable hearing in many ways, a hearing that certainly was different in its intensity, different in its personality than just about any motions hearing I've had in my career. So the first motion that we filed was an unlawful command influence motion. And that was because there were numerous statements made by John's commanders that we felt needed to be brought in front of the attention or in front of the military judge. They were statements that seemed to insinuate they didn't have really much decision-making power in this process. And this is back again in the old system where the command had court-martial jurisdiction and the ability to refer cases, whereas now, of course, it's different, right? And so we believe that there may have been some UCI that had committed by the JAGs that were working the case. And we also believe that some of the statements made by John's command chilled the court-martial process. So that was the first motion that we filed. The second motion that we filed was the largest and most massive request for the production of evidence motion that I have ever filed in my entire career. Remembers well, it read like a novel. It was, a novella, I guess, right? It was about 75 pages. With the attachments of the evidence, it went well over 400 pages. And what we were asking for specifically was the alleged victim's phone and the communications that she had saved in the iCloud between her and John, because we had concrete, solid evidence to show that, number one, those communications existed. That was beyond dispute because we had a number of them, and she had just deleted a lot of it by her own hand. And we had the evidence to show that those communications not only happened before John and his accuser met up on the 2 occasions, but also during the meetups and immediately after the meetups and for months afterwards, where they continued on with communications that were sexual in nature and clearly showed consent. So we get to the motions hearing. We're lucky that we had a very competent judge. I think she did a very good job. She had spent her career on the appellate side, and my job on this particular day was to show how vital these phone records really were. And we hired and brought on a friend of the podcast, Kevin Peden,
who's going to be on the podcast
shortly. And he provided a wonderful affidavit about the evidence that was out there, about how he could get it, about how he could extract it, about how it still existed. And we end up calling first John to the stand, and he does a brilliant job of articulating that these messages were exchanged, that they still existed. Here is the content of the messages. And then we called the accuser, and I examined her for about 30 minutes. And she actually said under oath, and if I'm lying, I'm dying. John, if I'm lying, you call me a liar on this podcast. She literally said under oath that she never deleted any evidence. And yet we had in our hands deleted evidence.
Yeah.
And she said, no, I never deleted anything. And she goes on and on. But then under what became a more intense, at this point, almost a cross-examination, even though she was my witness, she finally admitted that yes, those messages probably exist, and yes, those were exchanged immediately after the alleged sexual assaults, and then for months afterwards. And so, on the motion to compel production of evidence, which it's very hard to get an alleged victim's phone. I mean, let me tell you, and the government argued over and over again the alleged victim's right to privacy. And they actually made an argument from my perspective that seemed to suggest that her right to privacy superseded John's right to a fair trial and his constitutional right to have evidence provided that helps his case. I mean, we're talking about basic production rules here. And the government actually argued that she didn't delete evidence. And again, I felt like I was in bizarro world. And You think the judge saw through it, though? You said the judge did a good job, saw through it, and you won that. So the judge did a very good job. She did see through it, and she immediately, within a day or two, she ordered the production of the phone and the contents of the iCloud, and it was a very, very big win for us. And that was what led to, ultimately, the dismissal of charges. But there's more to the story. We also had the UCI motion. And in this particular motion, we argued, like I said, some statements that were made by command and some statements, some things that occurred with the prosecutor's office. And John's brigade commander, no nonsense, testified that he didn't even really remember signing the preferred charge sheet. He was just told to sign it by the military prosecutors, and he couldn't share any details of the case because he had no memory of actually reviewing the evidence in the case. And I thought that was a slam dunk. We have won the UCI motion, and we may even get a dismissal of charges. The judge felt otherwise. The judge had gave a written opinion via email. She never published an opinion where she essentially said, I think this is bad, but it doesn't rise to the level of UCI. But so this guy didn't remember it at all. No. It was like he was signing a check for the electric bill. He literally said something like, they put it in front of me to sign, so I signed. I can't even exchange or share details of the case because I don't remember. And if I did review it, I don't remember now. So we had this massive victory on the production side and a disappointment on the UCI side, but it became very clear at this point we were in the driver's seat. We had the goods, we felt momentum, and we used that to get the result that we did. But what I want to do now is I want to turn it over to John. And John, I want you to share a little bit. We don't have a ton of time left, brother, but I do want you to share a little bit of what was that process like being with us in court, seeing your lawyers cross-examine your commanders, seeing your lawyers examine your accuser. What was that day like for you?
It was the first time that I really felt any semblance of hope. Up until these big dates, if you're going through this, you're gonna feel like nothing's happening, and then everything happens all at once. I will corroborate Rob's story. He was brilliant. It made me tear up. It was like, in a lot of respects, it was like I was watching a movie. Particularly when Rob told the judge, Your Honor, my client's innocence is on that phone, and that was kind of the ending of his argument. And when I got up there, and so often in this case, I always felt like anytime the government had an opportunity to talk to me, they floundered. Because I got up there to Russ, like Russ said, I testified, which I was putting myself on the line to do that. Like they could have charged me with false official statements if they didn't believe me. They could have, tried perjury. It's a risky move as an accused to get up there. And the only question, I will say, they only ever asked me one question, but they in reality asked me two. The lead prosecutor looked me in the eye and goes, "John, would you say you're a liar?" And I said, "No." And then he's like, "Well, would you say you have problems with the truth?" And right there, Rob and Matt Jubelt, they got up. Matt immediately objected, saying that they were just trying to humiliate me, which they were, and it was a humiliating process. But Rob cited, honestly, a very impressive, to the layman's perspective, very impressive argument on why they can't be speaking to whether or not I'm lying, because it hasn't been proven that I was charged or, that I committed any crime. And the judge walked away for a moment. We sat around for 10 minutes and, we were like, "Hey, you're going to have to go back up there and you're going to have to, you're going to have to answer questions. Just be ready." And the judge was like, essentially said, "No, I agree with the defense." And the government never asked me another question for the additional, 16 months we spent waiting for trial.
And this kind of ties back, Matt, into the episode we did on the Military Rule Evidence 100 series, to tie it back to that, because I believe it's MRE 104, maybe it's 103, talks about the rights of the accused when he takes a stand on a preliminary question. And the government cannot use that as an opportunity to prove up their charges, which is what they were trying to do. They were trying to prove up some of the false official statement charges or whatever it was. And the judge did not. She took about 15 minutes, and that was the last questions they ever asked John. And so, John, we could probably have done a 2-hour episode with you, and I apologize that we've got to kind of fast track this a little bit. So I want to move forward and talk about, a few months after the motions hearing, we find out, hey, they're willing to dismiss the rape and the sexual assault charges. What was that day like for you when you realized that at least the major battle, the major battle, that war that we were fighting, that it was done and that it was over and that you were going to survive this?
It was bittersweet. To be clear, like the dismissal offer only ever came after the exculpatory evidence that the government has had throughout the entirety of my process was finally granted to us. And so it made me feel like this the entire time that I went through this, it was political. Notwithstanding, though, I was also extremely grateful. And I remember I sat down with my family. I kind of talked through the potential consequences of this, which ultimately none, at least punitively. Administratively, that's another story. But I was sentenced. I fled out. The charges were dismissed with prejudice, and I was sentenced to a reprimand. Despite the government's best efforts to have me forfeit pay, I remember when the judge said, Captain so-and-so, right, not to dox myself, I sentenced you to a reprimand, and that's my sentencing. And then when I finally got the reprimand, it was 3 sentences. Not very, strong. I had harsher words spoken to me before that. And me and Ross talked about it, and we were just kind of floored by this whole process. Of course, there's the overwhelming relief that this is over. You get to move on. But then there's the uncertainty of the administrative process.
And John, that's a good point. And this is a point that I should not have glossed over. Well, it turns out that the government had a good portion of the communications in their possession that we were fighting for the entire time. They just never went to CID and looked at the entire file, and they never provided the entire file to us until after we filed those motions. And on one hand, the learning lesson from the defense is always go to CID and go see the actual file yourself. Okay. But we also strongly considered filing a prosecutorial misconduct motion because we put our client on the stand at the risk of perjury when they had these records the entire time.
Yeah, and we should do an episode on prosecutorial misconduct, because you have a lot of cases where evidence is withheld. You've had some recently where evidence is withheld and it either delays it or results in some sort of dismissal. We don't have time to cover that today,
Right.
But it's not a rare thing, right? It's not a rare thing.
It's not supposed to be. It's not supposed to be. And I think by and large, military prosecutors do a good job of turning over evidence. That being said, this case, my opinion, my conclusion was not an intent to withhold exculpatory evidence from us. I think it was pure and utter negligence.
Yeah.
They never cared to find out the truth. All they cared about was this alleged victim was threatening to sue them. She was threatening to go to Congress. They didn't care about anything else. So,
and whether it's intentional or negligence, the result for your client, unfortunately, is still the same.
It's still the same. And then when that evidence was finally put forward and they recognized that everything John had been saying was true, but I think even more importantly, they recognized, and excuse my language here, Matt, they recognized I was going to beat their asses all over that courtroom from Monday to Friday. They finally did the right thing and dismissed the rape and dismissed the charge with sexual assault with prejudice.
But that's not the end of the story.
That was not the end of the story. We had a conduct unbecoming charge. John got a reprimand for that. And then following the dismissal with prejudice, the command eventually moved for separation against John for the very same sexual assault allegations that were dismissed with prejudice. And that goes to show you that the criminal side and the administrative side are two different things. Now, ultimately, winning this case to the criminal side was far more important for John, because that was a massive win. You're talking about rape carries with it a potential life in prison. But John, why don't you talk to us and we can kind of finish this episode out with what it was like to still be told by your command they're separating you for this. And then I want to talk about any advice you have for our listeners about the light at the end of the tunnel, and anything you want to share that you think could be healing for the folks that may listen to this show, who are going through a similar process.
Yeah. Well, for starters, the command never told me that they were separating me for sexual assault. In fact, they had me in limbo. I waited about 6 months before I was finally told what the disposition of my separation was going to be. They did separate me with an other than honorable discharge, and that, stings. But it's not the end of the world. We'll get into that in a moment. But when I had asked my commander, because I've been asking for months at this point, I asked my battery commander, hey, can I see the chain of command recommendations? Because I'm supposed to get that packet. And they told me basically that I wasn't entitled to that packet. And so I had to go through TDS to finally get that. And there was a split opinion, essentially amongst the command. The certain members of the command were like, no, separate him with another non-honorable. And these are new commanders. They didn't know me at all. And they were just like, piece of garbage, first human being, dishonors the uniform, get him out. But then the only commander that had been over me throughout the entirety of this process, the only guy that really asked any questions, and ultimately, a commander that to this day, I'm pretty humbled by him putting himself out there for me. He had actually recommended a general discharge, and given the circumstances, I can understand that. And when it was all said and done, and he's since written basically for the VA, a letter saying that what happened to me was wrong and I deserve more than what I'm getting. But it kind of was just, even when all said and done and you score a complete and utter victory over some very serious allegations, all the local command, at least these local commanders saw, was this guy had once been accused of sexual assault. Notwithstanding I think it was over 1,000 pages of evidence that had come out over the 3 years we did this, notwithstanding the nearly 40 character statements from every rank that I successfully ever served with, both in combat, garrison, notwithstanding the fact that the local battalion commander didn't report the separation, all brigade legal did was present a criminal complaint, and they separated me because of sexual assault. To get into kind of the aftermath of that, no one wants to be a part of this club because you have gone through this, but I've been very fortunate to meet some very phenomenal, just being honest, young men that have experienced a similar situation, and they are experiencing it with the OSTC. And that was the reason why my charges were ultimately dismissed with prejudice, because they brought someone on from the OSTC to really take a look at the case. I see these young men going through it, and I've seen them from the start of their investigation to them getting notice that, hey, they're not pursuing charges, but we're still going to put you up for separation. And even if they separate you, even if they give you bad, quote unquote, bad paper, there is that light at the end of the tunnel in the sense that, one, I'm free. And no one's ever going to take that away from me for as long as I live. I was a law-abiding citizen while I was in the military, despite what they want to say. And I'm a law-abiding citizen now. Two, I'm very fortunate to have found employment that allows me to keep a roof over my head. And three, when these things happen, it's still not over. When you remove these bad actors, and I'm going to call them bad actors, Rob, I know that you consider the prosecution to be negligent. I consider them to be, choice words, but
sure, I don't blame you. In this case, I do not blame you.
When you finally remove these bad actors from the process, and you get competent representation, like Rob has alluded to, I'm being represented by his firm still to get my discharge upgrade, to deal with the VA. You will be, for lack of a better word, vindicated. And whether it's you're in the Army, whether you're out of the Army, your life will go on. And that was honestly the biggest point, the biggest thought that we considered when we finally decided, because I wanted to take the trial. I was so frustrated by it all. But I remember when I told my command the reason, when all was said and done, why I chose to plead out, I told them it was because I loved my family more than I loved the Army, which was an inverse of what my life was like prior to that. I had loved the Army with every fiber of my being, and it's a shame that my relationship with it turned out to be what it was. But I wanted to be there, and there are so many wonderful memories, as Rob has alluded to, in life, on previous conversation podcast, that I wanted to be there for, and I don't regret it for a minute.
And, John, I appreciate you sharing all of this, and it's important to know for our listeners that you can win your case. You can be victorious and win the biggest battles. And under this political climate, they're still going to get their pound of flesh from time to time. And I think it's also important to understand that there are two sides to every coin when it comes to the sexual assault issue in the military right now. And the pendulum under this current administration has swung so far in the opposite direction that there are young men like John all over the country who are being falsely accused. And John is lucky that he found us, because not everybody has the means to find good lawyers, and they get stuck with public defenders who may or may not care that much about their case. And it's scary times right now. And John, I appreciate you sharing all of that. I hope that brings some healing to you. I hope that it brings some healing to folks that listen to this episode that may be going through what you're going through. And I want you to tell you how much I appreciate your support. And you have my word that we will follow through with the discharge upgrade and also help you on the VA side as time goes on.
Yeah, I appreciate it, guys. Matt, again, pleasure to have finally met you. Looking forward to listening to every additional episode and every other time you ask what the favorite military movie is.
Well, thank you so much. It's a hard thing to go through what you did. I got the chills a couple times listening to you mostly talk about how it impacted you. We could have talked about a million things. Could have talked about how it impacted your family. We could have talked about the motive behind the accusations. We didn't get to any of that. But it was certainly an honor to have you on the show, and you are a patriot. And we're just grateful for that. So we wish you the very best. I know Rob will keep in touch with you as he works on your stuff. But thank you again, sir, for your service to our country, and also for coming on Military Justice Today podcast to talk about your experience. And with that, we will close out. We thank everybody for listening. We've got plenty of podcast content coming out, so please continue to tune in. Until the next one, take care and be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.